but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
Yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under a state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the state that.
Just know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her here at 9 a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a judge?
Mr. Brooks, I need to make a record of some things.
I need to make a record too.
You don't.
When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to make.
I'm gonna give you what you know is coming.
I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
the contract between you and I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what is?
I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to the next
Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's I know I'm muted, so.
Not yet, okay. Okay, that's fine, just need to know. Can they confirm that
Am I
the
muted?
audio and visual is working? We don't need a clerk per se, we just need
Just
to
let
know
them
that
know
the
we
audio
can
and
hear.
visual is working.
It is.
Am I muted?
Record to reflect that Mr. Brooks is in the adjacent courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those, and once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness, who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word, it's a synonym for badgering. Clearly he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is, and then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146 Wisconsin 2nd 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 906.11, and the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial, and of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So, just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks, and I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of right now, Your Honor, just so you know for timing.
Thank you, I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. It's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes. Sure. With the hope of, and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with, so I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's gonna take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared, perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions, and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now.
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of at this point on the topics that have been raised. Sir, anything you wish to address before we break for the day?
Yeah, I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them. That has yet to be done. I've put you on notice and I've stated it on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up. 4 against 1. Then you sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we gonna strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt. Why was the bond not addressed? Why was the statement of particulars not addressed? No filings that I seem to file need to be addressed. After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel, and you accepted that. But you still turn around and continue to violate my Sixth Amendment right. You violate my First Amendment right by telling me what I can and can't say, which I have the right to say whatever I want to say and to be heard. That's the First Amendment. You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, 1, that I wasn't prepared, 2, that I did not understand the proceedings. But yet still you choose to find a way to get around it. just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair. Doesn't constitute being impartial. When the jury was selected, I struck the whole jury. That never got addressed in any way, shape, or form. When you knew, when you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.